Alright guys, let me get a mic closer here. Yep, we are recording. Alright guys, my name is James Clark, and I'm the advocate in the High Supreme Court. Has been appointed to record part 1 and part 2 on the customary law. Part 1 obviously being Islam law, part 2 being indigenous law. So for the next hour and a half, it depends on how far we get, but about an hour and a half we are going to be busy with customary law, Islam law, and we're just going to work through the guide. This is just an assistant, a resource that you can utilize with your guide, and we can go through the guide together and we can see what is in the guide. So let's scroll up down. Hopefully in this recording you can see I'm scrolling up and down, so that's kind of important. Alright guys, this is your guide, this is your training guide. You all have many of them, and I'm gonna scroll down. There's the preface to the practice manual. They tell you a lot of stuff in there. You got to go through that in your own time. I'm not very interested to go through that. There's your table of contents. It tells you that part A, part 1 or part A then is all about Islamic law. So actually we are looking at part 1, and under part 1 we've got Islamic law, Muslim personal law, and we also have economic consequences of divorce. We've got a lot of things going on there. C is Muslim personal law in South Africa, and then D is other religions around South Africa, and then we'll just touch on other religions from the foundation of Muslim law and Islam, and that would be Christianity, Hinduism, Buddhism, Judaism. And this is actually on the foundation. This is done to say that we don't deem any religion more important than another, but most of our court cases explaining customary law and explaining how religion plays a part in our law, in the development of our law under the Constitution. We are stuck with a situation. Most of those cases are stemming currently from Muslim law in South Africa, of the demographics. We'll show you the demographics. If there's more of a certain religion, then obviously percentage wise you will get more court cases there under in developing what is happening in South Africa in terms of all these things. Part 2 there we will move on to a more indigenous law. We'll be looking at all of those social structures, etc., etc. You'll see what's going on in indigenous law right through that. There you are, African customary law obligations. We'll be talking about Labola and all of those things under that law there, and we'll deal with the law of the league under that. You'll see the Utwala and all of those things going to be talking about, and you'll see what's happening there. This is how customary law has been approached. It has been approached to deal with Islam, and has been approached to deal with indigenous law, and there is not a reason why Islam is first and indigenous law is first. Really nothing at all. It's just the way the parts were put together. Let me explain it in a better sense. These were two guides, and they've been put together, and that's what that's all about. Alright, so nothing to worry about. There's your customary marriages under indigenous law. A lot of things we're going to be looking at there. Alright, and then if we go there, now your guide might present it differently to mine, because I'm working on the still in process guide, which is the same as the guide coming out in 2022. So if you don't have this, and actually we are doing this for 2022, but my guide is still a process. It still has to go through finalization, and it might present itself a little bit different, so just bear that in mind, and then we'll take a look from there. Alright, there they give you the learning outcomes, what's in the guide, and so on, and we're going to start here. Alright guys, part 1, Islam law, and at the end of part 1 we'll deal a little bit with other religions too. I've explained it, so all I'm going to do is I'm going to systematically go through the guide with you, and we see what's going on here. It's very fascinating, it's very interesting, always a passion for law, any kind of law, and I want to impart on you guys, if you are listening to me, that you must have a passion for what you are doing, as if you're going to be legal practitioners. Passion, integrity, honesty, all of those things are very, very important. They say the definition and concept of Islamic law, the root of the word Islam is in an Arabic word is Islam, which in essence means to feel at peace with God and mankind. Now, especially when you look at mankind, you will think constitutionally wise in South Africa, because if you look at chapter 2 of the Constitution, the Bill of Rights, you will immediately understand that that's the fundamental rights, is to be in harmony and peace with our fellow neighbors in South Africa, fellow citizens. Purity, submission and obedience can also be ascribed to the meaning of the word Islam. So that is then kind of the definition there. There's a lot of other definitions. That's the best one for that. In the religious sense, the meaning of Islam is the complete and total surrender or submission to the will of Allah, God, and to His laws. And we know that in Islam, even the Muslims, we know they're very dedicated. They maintain the times they have to pray, and they will close their businesses. They are not making money on those days. So that is what that's all about. There is a connection between the root, and I'm not going to read everything. We're going to move through this guide. We only have an hour and a half for each part, so I'm just going to touch here and there and go through it with you. There is a connection between the root and religious meaning of Islam, as Islam advocates the view that it is only through the submission to the will of Allah and by obedience to His law that one can attain true peace and joy, everlasting purity. So that is something there. Go and read up on all of it. I'm not going to read it all because I've only been allocated an hour and a half, and otherwise we're going to run into trouble. If we do end a little bit earlier, that's also fine, but we cannot go over the allocated time in these clips. There I talk about the important aspects in respect of Islam. Islam is a monotheistic religion. This is belief in one true God. All adherents of Islam are commanded to do good deeds and to abstain from evil. All the followers of Islam are treated equally, irrespective of race, color, language or nationality. You see that in the media, you see it in the movies. They accept everybody as long as you adhere to what Islam teaches then. The commands and principles of Islam are applicable to all Muslims without distinction, and these commands are prescribed by Islam must be executed by all Muslims. Islam is a religion of peace, and as such advocates that human beings respect and show mercy, to one another, cooperate and work together for the good of society in particular, and for the happiness and prosperity of mankind in general. So there you have the important aspects, and these are the aspects you have to consider also, because obviously what's happening, why are we teaching this? Because mankind stems from religion. Our laws was religion in the beginning. In the beginning you didn't have a difference between religion and law like we have it now. If you think of biblical times and Quran times and Talmud times, then you would see that the law was derived from those books, and those books were religious books. Later years, as we moved through the ages and we arrived at the age what I call currently the age of fundamental rights, human rights, the age we're living in, and you think about chapter 2 of our constitution and all our promulgated legislation, to a certain extent we progressed through history in which religion started standing to one side and law starting to the one side, and many religions do not accept this at all. Example, Islam. If you think about our constitution, and the big issue always is marriage, and our marriage is governed and our divorce is governed, and then of course all the religions, Islam, Christianity and Buddhism, doesn't matter which one we're actually talking about, they come into conflict with our statutory legislations, our common law, etc., etc. So at the end of that creates animosity, that creates unhappiness, and then of course people go to court. And what does our courts do? They apply the constitution and our statutory legislations promulgated from our constitution, because it may not be in conflict with our constitution. And this is why you have to know these important aspects in respect of Islam. Islam is the most court cases in South Africa we have out there, but at the end of this part one will show you that all the other religions are mentioned in our courts up to the constitutional court. This one is just the most, and that's why we're using it as a foundation for our customary law to look at it. And this makes people very unhappy, but even people under Islam, under Christianity, under Buddhism, all of these people still runs to the court, regardless of what's happening within the religion, and still the law they're applying, they're very strict. I mean, Islam is very strict, Muslims are very strict. We cannot say that to a certain degree from Christianity, because this was predominantly a Christian country, and we have our promulgated legislation apart from that. And interesting enough, you won't see that on a religious foundation too much that we go to court, but in terms of other religions, that's very strict. Obviously democracy and our constitution can present a problem, and our courts has the last say in terms of what our constitution is dictating. It's very hard, it's very difficult, and it makes a lot of people also very unhappy. You'll see we have a Jewish case also here, we'll show you later on. So that is why you're showing the important aspects, what you have to do. If you ever litigate on a case like that, you're going to look at the important aspects of Buddhism, important aspects of Judaism, and so on, to actually bring an application to court, because you have to show where you are coming from. So that is very important. That is why you have to look at that. Let's move on there. Let's talk a little bit about the nature of Islamic law. The crucial difference between Islamic law and Western law can be deduced from the definition of Islam. The unique ground of validity of Islamic law is that it is the manifested will of Allah. In other words, it does not depend on the authority of any earthly lawgiver, as is the case with the Western law and our constitution and our statutory laws, because you can imagine that where people say but it's a manifested will of Allah and God, then that supersedes everything for them in their hearts, in their minds, and it becomes quite a battle in court when we roll out a constitution and we say to people in the Islamic law and Buddhism, in Judaism, and also to a certain degree in Christianity, but hey, our law is not going to stand for that, aspects like that. In Christianity, I'm thinking about Jehovah's Witnesses. There's a couple of court cases there that's very interesting, and so on, but that's a subdivision of Christianity. So there's unhappiness. It doesn't matter where you go, there is unhappiness, and then our courts has to adjudicate on it, and they make rulings that's not very popular, because they make those rulings under the constitution, and then they go against what people believe, and what the people believe is very strong. So that is what's happening then there, and then of course, like I say, that creates animosity, but we all have to be under the constitution. It is a rainbow nation, and it's very difficult. We cannot have a law, a dependent law for everybody. That would just be too difficult. This difference has two main consequences: the Western law, and then of course where Islam law says, well, manifest as will of Allah, that's all that stands. The first consequence is that Islamic law is the principle immutable, for it's the law revealed by Allah. Western legal systems generally recognize that a content of law alters as it is adapted to changing needs by the legislator, judges, and all other social forces which have a part in the creation of law. Now, I don't know if you're familiar with the terminology calculus. Calculus means we live in an ever-changing world. And as we live in an ever-changing world, things change, law change, circumstances change, and that's actually what I'm saying here. It's a adaptable changing of the needs of the legislature, the judges into the future. The calculus plays a big role in this, of how our societies are shaped, as our calculus is keeping on changing. We don't live like in medieval times anymore. So 100 years from now we might live in space, and our calculus keeps on changing, and that is how judges and legislators look at it and applies law now. And that's totally different from religion. Why? Religion does not have a calculus. If you talk about the Islam law, you talk to Muslims, they say no, there's no calculus in what we believe in our religion, because strict Christians too will tell you there's no calculus. God is the same, Allah is the same yesterday, today, and tomorrow, forever, and they come from that viewpoint. In a democratic dispensation, their calculus is important for lawmakers, and this is where the conflict comes in. All right, this is how when you do this subject, you've got to start thinking a little bit out of the box. It's unfortunately not black and white. There's very grey areas. They go on there. They say Islam starts from the proposition that all existing law comes from Allah, who at a certain moment in history revealed it to man through his Prophet Muhammad. Thus, Islamic legal theory cannot accept the historical approach of studying law as a function of the changing conditions of life. Changing conditions of life is the definition of calculus. There you have it, in a particular society. On the contrary, the law of Allah was given to man once and for all. Society must adapt itself to the law rather than generate laws of its own as a response to the constantly changing stimulus, the calculus of the problems of life. So they are saying that calculus must remain forever subject to religious law, and in the modern world we live in, they are saying calculus is paramount, and as societies change, law must adapt, and that law can be in contradiction with millions of years or thousands of years, not millions, but thousands of years old religious law. So this is no easy thing. Everybody out there, this is no easy thing. And we do see wars right throughout of the world on this very topic. It's very interesting. The second consequence results from the fact that the will of Allah covers all areas of life and not simply those which are of interest to state or society. Islamic law is inextricably intertwined with the belief system and the moral values of Islam. Thus, Islamic law regulates the prayers a Muslim must make, the periods of fasting he must observe, the alms he must distribute, and the pilgrimages he must undertake. Whilst the observance of these precepts may not be enforced, Shari'i is a comprehensive ethic or doctrine of duties which controls the entire earthly existence of Muslims and shows them the way in which they must perform their religious duties in order to earn the promised reward of bliss in a better world. So there you have it. That means that at the end of the world, they are not interested in the evolving world in terms of where this evolving world calculus overshadows their belief systems. They are interested in evolving world. They don't have problems with progress, nothing, but subject to the religious laws, which comes directly by the word of Allah, by the word of God. And this is very difficult. I mean, serious wars break out in the world due to this. And if we think years ago about Syria, Bosnia and those places, there were so many ethnic groups, Christians, Muslims and other groupings, that was one of the worst wars with the baddest atrocities we have ever seen in our lives in the modern world. And this is one of the reasons for that. And we must be very sensitive as legal practitioners when people that are passionate walks into our office and we deal with this. All right, it's very, very, very important to understand that emotions is going to play a big role when people comes into our offices and they want to take something to court. And we must be very careful not to just be cold and ununderstanding when we deal with this kind of law. In any event, when you deal with divorces, you have to think further, because that's one of the things that is important in terms of that we have compassion for the people sitting in front of us. Then they give us the sources of the Islamic law there. That's very important. You can go through that in your own time. What I'm going to do is I'm going to go through the sources. The primary sources of Islamic law is, first of all, the Quran. I'm sure you all know about it. The Quran for the Bible, the Christians the Bible, for the Jews the Talmud, and so it goes on. So every religion does have its source. And for the Islamic law, there's a few. The Quran, it's the highest and most important source of Islamic law. There are only a few of the statements in the Quran constitute rules of law capable of direct application. It consists mainly of precepts of proper ethical behavior, even where it deals with legal problems in a narrow sense, such as those of family law. And that's the problem. Divorces, etc., etc. That's the problem. That's why a legal practitioner, we must teach you this side of a subject of law, because you're going to get it a lot in your office. It does not offer an integrated system of legal rules, but simply gives the solution of a few individual problems with which Muhammad was concerned as a judge and prophet of the law. So the Sunnah, literally speaking, the Sunnah means a manner of acting, a rule of conduct or a mode of life. In essence, Sunnah refers to the traditions of the Prophet Muhammad, which includes his sayings, actions, and approval or disapproval of the actions of others. The tradition of the Prophet Muhammad is an important source of Islam, as it demonstrates the manner in which a certain injunction mentioned in the Quran has to be performed. The Sunnah constitutes the guiding principles to which all Muslims should strive to adhere. Okay, so first of all, these are the first important sources. They call them the primary sources, as you can see there, the Quran and the Sunnah. Then there's more sources. They call them the secondary sources of Islamic law. The Ijma, excuse me if I can't pronounce correctly, the Ijma, it literally means getting together, and originally signified the consensus reached by the entire Islamic community, laymen as well as lawyers, on a question of the doctrine of the duties of the faithful. Ijma refers to the consensus amongst Muslims jurists in respect of the questions of Sharia that are not allowed to be in conflict with the Quran or Sunnah. it has practical significance. A proposition was to be regarded as a rule of law if at any time the living legal scholars of all or even one of the schools of the law agree to the ijma. I struggle with pronouncing that, my apologies. The qiyas, the analogy. Qiyas refers to the analogical deduction that enables a Muslim jurist, after engaging a process of study and reasoning, to transfer an existing rule by analogy to a similar situation. Qiyas is the application to new and similar cases of rules established by the Quran, the Sunnah and the Ijma. Thus, if all three of the above mentioned sources fail to provide a solution to a particular legal problem, jurists must strive through reasoning and study to derive an appropriate rule by analogy and logical reference. And that is what that is all about. That is then the primary sources and the secondary sources of the Islamic law. Alright, so guys, whenever there's a problem, now, it doesn't mean that court cases in terms of the Islamic law will always come to you if you are a Muslim. Most of the time they will seek out attorneys and advocates that is of the same faith, but that doesn't always happen, especially for example if you do pro bono work or the legal aid board appoints you, whatever the situation might be. But in many cases, for some reason, people that want to oppose issues within this religious laws will go to somebody that's not part and parcel or have a faith basis in these laws, because they will want somebody to bring an independent application. That might be you. So you need to know these things. There's a lot of these court cases in our South African courts up to the Constitutional Court. So that's very important. Islamic legal theory versus Western human rights perspective. We know there's an age-old battle between Islam and the Western ideologies. In the sense that the Western ideology is very sinful and opposes the Islamic law. And that's our bad wars. We're not going to get into that. We are not going to get political about that. As indicated previously, the primary source of which Islam based all its beliefs, principles, rulings are the Quran and Sunnah. As Muslims believe that the Quran is the literal word of God, Islam is regarded as divinely revealed religion. Therefore, the pillars on which Islam rests are infallible texts that were set down from heaven, are represented in the verses of the Holy Quran and the texts of the prophetic Sunnah. So you can imagine, you must apply this in all faith foundations. No, don't let your mind only think Islamic as I'm talking, in the general context. When we read specific aspect about Islamic law, yeah, then sure. But as I'm speaking here, remember we've got Buddhism, Judaism, Christianity. So in the general things we are saying, keep an open mind. Alright, so that's what I am saying there. And you can imagine that if this is the literal word from God to any faith basis, people that are very religious is prepared to die for this. So emotional, passionate, you have to be careful when you deal with these things in your office. The fact that all Muslims, no matter where they find themselves, are commanded to adhere to the rulings and principles can be seen in chapter 5 of the Quran. Let's just do a few of them. So there we see, and so judge between them by what Allah has revealed and follow not their vain desires. Chapter 5 of the Quran furthermore also says, issues a warning against compromising on any detail of Sara'i, no matter how small it is, with the following verse, but beware of them lest they turn you far away from some of that which Allah has sent down to you. So these are very, very strong indications to abide by the law and not in the smallest iota step right or left of it. So this is the things that's important, and this is law. This is law. There's a lot of countries in the Middle East that doesn't have any other law. This is their law. They don't have like the Western worlds, and we're also very much Western. A lot of people will argue about it, but they don't have a law apart from a religion. Women has to close their faces. They cannot talk to other men, and they cannot work. And we've seen, a lot of things going on in the world about us. This is very strict principles, and they don't have Western laws by no means. And that's why one of the things they will always first oppose is democratic dispensation, because democratic dispensation brings human rights. Human rights brings statutory legislation that nowadays 90 to 99% would be against certain of these religious values and foundations. And if you are saying it comes directly from God, it creates a serious problem for litigation and people that wants to stand fast on it, and the people that wants to oppose it, especially family law, especially divorces. Alright, so there's a few you can read there. They also give you a few explanations of terminologies there, so it's important that you keep an open mind, as I've said. The above verses clearly illustrate that Muslims are required to adhere to the teachings of the Quran regarding what it permits and what it forbids. Muslims are required to obey its commands, avoid that which it prohibits, pay heed to its lessons, and not overstep its limits. This remains the same whenever Muslims find themselves whether in South Africa or any other place in the world. Islam is a religion that guides Muslims in all aspects of human life. Now you can think for yourself, in South Africa, in America, in the developed world, then obviously it comes into conflict with law. And then when you get to our first court case, let's have a look at it. Taqwa is what guides practicing Muslims in their desire to conform to the teaching and principles of Sharia. A case in point is the decision of the Indian Supreme Court. So we're now in the Indian Supreme Court. In Mort Ahmed Khan versus Shabanu Begum, that was 1985, where the court made a decision with regard to spousal maintenance that was contrary to the principle of Islamic law. Can you see what happens? What happens throughout the world? And that hurts people inside. Because most people that has a strong faith foundation would say, but I want to follow my faith. This cannot be allowed. But then you get into places where there is a democratic dispensation, constitutional fundamental rights, legislation has been promulgated out of that supreme Memorandum Constitution like in South Africa, and most of the time it doesn't say what a faith-based religion is saying, and at the end of this division we'll show you in South Africa how the faith-based religions look. In this case, the court granted the plaintiff, a 70-year-old Muslim woman who was divorced by her husband, maintenance until her remarriage or death. The court's decision was based on the secular law of India. The secular law, when we talk about religious faith, you would always say, well, you know, I am a Christian, I am a Muslim, I am a Jew, or whatever the situation might be, and that is my religion, and I do not condone to the secular world. We refer to the secular world as being a world out there, the economic world, the world beyond the religion, where people don't base the decision on religion. They don't really have a faith basis. They believe in money, they believe in beautiful wives, they believe in great jobs, great businesses, luxury, and all of those things. Not that it's wrong, but that it is wrong if you derive them from a human faith basis and not a religious, God-orientated faith basis. Wow, that was an interesting statement I just made there. Don't know where that came from. So that is the secular word versus the religious word. If you don't know what was meant with this, the court's decision was based on that. The court overruled the husband's objection that in terms of Islamic law, she is not entitled to maintenance for a period of 3 months after the marriage is terminated by divorce. Islamic leaders rejected the decision as unlawful interference with Muslim personal law, and argued that the secular courts took it on themselves to interpret the Quran and thus disturbed the understanding of India's society that was based on privacy and the autonomy of the chosen personal law. Shabana herself eventually wrote a public letter declaring that as a true believer she now understood that her actions were wrong, and that as a good Muslim she was rejecting the decision of the Supreme Court. Therefore, if a secular court makes a decision that is not Sharia compliant, the parties themselves will not feel bound by it. So yeah, well, you know, she went to court, and later she changed her tune. So one can imagine, we don't know, was there dangerous pressure on her to turn around, because obviously she applied for maintenance, and now after this ruling was made, she turned around to say, okay, no, she doesn't agree with it. So it's kind of a little bit of mock-up there, but it shows you also the power struggle between religion and the secular world. In the secular world, they said, well, under democratic rights, we have to do right by this woman. She's 70-year-old, where she's going to know, you have to look after. And in the Islamic law, or let's rather say in another religious law, they say, no, the word of God says is we have to follow it, and there you have the conflict. All right. In contrast, I say that the basis of modern Western democratic societies is a constitution that is premised on human rights and equality, and that advocates the notion that the rights contained in the constitution rule supreme over all matters, religion included. That creates the problem. Therefore, where a conflict arises in respect of the freedom of religion and the right to equality, Western ideologies and philosophies dictate that the latter trump the former. And we are seeing it in South Africa. And what do we call it? We call it the balancing of rights. And unfortunately, in most court cases, on the foundation of democracy, I shouldn't say unfortunately, but what's basically happening out there is that in the balancing of rights, most of the time, religious faith foundations must stay back. And that is due to a secular world, Western ideologies, and democratic rights. Let's get away from Western ideologies. Let's get away from the secular world. Let's bring it down to what it is. It stands back for democratic rights, human rights, as the world are evolving forward into the freedom of man with a charter of fundamental rights and human rights derived from a constitution. So that's what that's all about, right? This would eventually mean that religious law would have to be adapted and ultimately amended so that it is in compliance with the constitution. From an Islamic perspective, this is not feasible. Not only from an Islamic perspective, but from many other perspectives. In South Africa, if the Supreme Court of Appeal or the High Court or the Constitutional Court rules contradictory to any religion, that religion has to abide, or there can be consequences. So this is the situation we are stuck with. And of course, most of us as attorneys, what do we do? When you become an officer of the court, all of those things, you have to abide with the law, you have to abide with the constitution, and you're going to have to be ethical attorney. If you're not happy with anything religious based, you have to bring it to court. And when you've gone through all the appeals up to the constitutional court, you have to accept what our court is saying, etc., etc. And that is the situation there. I tell you, this is a very difficult situation. If we go down, stroll a little bit down there, we'll see constitutional principles were interpreted in such a way to grant recognition to customary marriage in terms of recognition of the Customary Marriage Act and so on, so notwithstanding the fact that equality concerns remain. The same should also apply to Muslim marriages. The problem is that they also wanted to bring into law, you'll see it in here, Islamic law promulgated through our parliament, but it's so difficult that there's too many arguments about it, because the one party says, but you got to bend over to our side, this side, and then the other party says, but then you violate the constitution, and it's a rope pulling situation, which is very, very difficult. The fundamental difference between Islamic law and other religions on the one hand and the South African legal system on the other indicates that Islamic law and other religions will never completely comply with international equality rights or with the South African Constitution. The conflict between the right to equality, especially insofar as a woman's right to equality is concerned, because it's about women, predominantly in all the religions, and the right to religious freedom will always exist in respect of Islamic law. The fact that Islamic law and other religious law is fundamentally different to South African law does not make it wrong, but merely different. It is therefore imperative that if South African society is to overcome past discrimination and achieve the vision of equality that is fundamental to a constitutional democracy, the courts as well as the state must recognize and promote a full range of diversity that is prevalent in South Africa. This inevitably includes the recognition of Muslim marriages in South Africa, and they are struggling to do that because to recognize Muslim marriages in South Africa, they have to be consistent with the Constitution. The Constitution says that customary law must be consistent with the Constitution, otherwise it will be declared invalid. And just there, the dynamite is ignited and it's ready for an explosion every time we walk into court. And as an attorney, advocate, you've got to decide, do you want to be part and parcel of taking these instructions, etc., etc. And if you do, you really have to be very, very careful emotionally wise how you deal with them. Alright, let's have a look at what is important, the recognition of Islamic law in South Africa. Before discussing the recognition of Islamic law and other religious laws, remember we're just using Islamic law because those are the most court cases going on currently. In South Africa, it is important to firstly discuss the fact that Islamic law, Muslim marriages in particular, does not enjoy legal recognition in terms of South African law because it's not consistent with the Constitution in terms of a lot of things. Reasons for non-recognitions, let's have a look at it. We cannot do all of it. We're already through half an hour here on the first part. Traditional religious personal law as Islamic Muslim marriage in particular was not recognized in South Africa. Firstly, the reason for refusal to recognize such systems of religious personal law have been based on the argument that marriage based on these systems are potentially polygamous and that this is contrary to public policy. In terms of South African law, the common law definition of a marriage is the voluntary union for life in common of one man and one woman to the exclusion of other while it lasts. Therefore, only civil marriages which are monogamous in nature have been recognized in South African law because they possess the element of exclusiveness. Now, I mean, on one hand, you're saying this, on the other hand, we've seen the president, the previous president of the country, having so many wives that even in the national leaders frowned upon it. So this is not easy in South Africa, and we are going to have to go through a lot of lawmaking in this sense, which is important for you there, because then predominantly Christian-based religions can also say, well, you know what, then we can also have more than one wife, because in biblical times, especially in the Old Testament, that was the way it was done. A marriage that did meet the requirements set out in terms of civil laws, therefore regarded as invalid. And you will see that our laws has changed a lot of marriage. There are so many changes there, and incorporated same-sex marriages. There's a lot of things going on there. From its conception, Muslim marriages have allowed for the plurality of spouses, which led to strong opposition from certain sectors of the Western world who refused to recognize these unions. In South Africa, Muslim marriages according to Islamic rights were viewed as contra bonus marriage because they are polygamous in nature. So go through all of this, read through all of this, that's important. Here we have a couple of court cases we need to read them because they show us how we are making law on these issues. Yeah, courts have treated the concept of, in the Carter case of 1972, so many years ago, courts have treated the concept of public policy with great circumspection, as evidenced by the remarks made in the following two cases. In Carter versus Carter 1972, Lewis said, public policy is a very unruly horse. Once you get astride it, you will never know where it will carry you. And this is very true. And then later years in 1983, in the Olsen case, we saw that Barron said, resorted to the conventional methods of finding answers to this problematic concept by asking the following questions. So what did he ask? Who are the public with whose welfare we are concerned? Now this case comes out of the apartheid era, so you can think where that went. How does one approach the problems in society in which there are several ethnic and cultural groups? Then he opens it up, strange enough, for everybody. Interesting, that already happened in 1983. He recognizes that, well, we're on an apartheid era, but we've got a rainbow nation, and he already recognizes that in 1983. When the persons concerned are members of such a group, is the court entitled to have regard to culture and traditions of that specific group in considering the question of potential harm? Or is the correct approach to consider potential harm to the society as a whole, but taking into account that society is not homogeneous? So that's the way he went about that. Despite posing these pertinent questions, because they're great questions, he was on the right track, but we have to word despite. Barron never provided any answers to the questions in his judgment. It is submitted that these two questions should have been answered in the affirmative, as when potential harm to society as a whole is considered, due regard should be taken to the culture and traditions of the group in question and of other groups, if any, with similar traditions. Now let me tell you what I think as a legal practitioner happened here. It was the year 1983. Apartheid was very strong. The major population controlling the country was white, and he's actually saying here, this is problematic, how are we going to deal with in a rainbow nation? And the reason he didn't answer his own questions, 10 to 1, he would have been fired due to the dispensation of that time. It's very interesting what's happening. You can actually see it between the lines. He's asking actually excellent questions for the year post 1996. So he was very open-minded, but also careful not to violate which could be construed in those days even as a criminal offense. So there is what he did. So that is so interesting. I love law, and if you can interpret law and you can read between the lines, that's so immense. Alright, now secondly, let's say Muslims' marriage have traditionally not been granted legal recognitions. These marriages are solemnized by an imam, a religious scholar. He's not a designated marriage officer as required by a statutory act. And that is what I was saying at the beginning of this. This is the conflict. Remember, Islam says we have the word of Allah. And we have those primary sources up there, and we're not going to play around with them. We have the Quran, we have the Sunnah, end of the story. But the marriage are not legal in another country, not only South Africa, don't get us wrong. If Muslims are out of their own country in another country, this is the problem. And I said unpromulgated legislation says that those marriages are not legal. So there's your problem, man. There's your problem. So what happened in May 2014? A pilot project. Now 2014 is way post 1996, the inauguration of our democratic dispensation. Let's see what happens here. A pilot project was undertaken by the Department of Home Affairs to train more than 100 imams to officiate over unions that will be recognized by South African legal system. The imams were required to attend a 3-day course during which they were educated on the Marriage Act. In addition, they were required to write an exam in order to be appointed as designated marriage officers. These imams are now authorized to act as designated marriage officers in terms of Marriage Act. The effect of this legislation is that the imams will be authorized to issue a marriage certificate in terms of South African law, where the parties simultaneously enter into a Muslim and civil marriage. The civil marriage, however, takes precedence over the marriage entered into terms of Muslim rights in the event of a dispute arising between the spouses. Notably, absent from the training course was imams from the Eastern Cape. So already there was a boycott. This was to a certain degree successful, but they say it very clearly. You were trained in terms of the Marriage Act, in terms of statutory legislation of South Africa. Just, you can do this, you can give our certificates. But the moment there's a dispute, we don't care about the Marriage Act, we're going back to the Islamic law. Do you see? Do you see the problem? Do you see the conflict? But at least South Africa is one of the countries that's trying to do something about this. Alright, so there they talk a little bit about the consequence of non-recognition. Despite the fact that Muslim marriages are not granted recognition in terms of South African law, Muslims continue to regulate their domestic affairs according to Islamic law, in that they are married by representatives of the Muslim clergy who performs the marriage in a mosque. If a breakdown of a marriage occurs, the marriage is effectively dissolved by the divorce talaq procedure. So you can see at the end of the day that didn't help actually at all. And at the end of the day, they are still going to go back because they have strong faith beliefs and they are strong in their faith, and they're just not going to bend to anything that can keep them basically away from Allah and being saved by Allah. And it's a faith belief. People are willing to die for that. So when you are a legal practitioner and you deal with this, you must be careful to take such an instruction. If you take such an instruction, you must understand that you need to know what's going on here, and you need to be emotional, and you need to be passionate about what you're doing. All these religions, very, very difficult. So guys, you can read through that. I want to go on because my time is running out on this first part. Let's go here. When parties enter into a marriage in terms of Muslim rights, the following consequences flow from the marriage. In terms of MPL, like we've said before, the husband is under an obligation to maintain his wife or wives and children according to his means. The spouse maintain completely separate assets, the spouses. Any contribution by a wife to support the husband during subsistence marriage regarding as a debt we just not prescribed. So there you have that there. That is under the Muslim rights. However, due to socio-economic conditions prevailing in the present day South Africa, a large percentage of women are forced into the labour market. This in effect means that women are contributing to the maintenance and financial support of their husbands and children, which is essentially the duty of the husband, as the latter bears the primary duty of support towards the wife and children in terms of the Islamic law. And this is the calculus in South Africa. This is in our times, society's changed. Women are now becoming the breadwinners. So what does even religious leaders do when this happens? It is very difficult, because if the woman doesn't go out and work in this difficult calculus changing environment of South Africa, there won't be food on the table. This is a necessity. It's got nothing to do with Islamic law, the economic fiber of South Africa. It's the times we're living in. Furthermore, they say, in terms of South African law, in contrast to Islamic law, a freehold period of prescription applies in respect of claims for civil debts. Do you see the conflict? Do you see the conflict? This makes it extremely difficult and almost impossible to claim for any contribution that a wife has made during the subsistence of the marriage when a marriage is dissolved. So there you have that. So you guys need to know. So let's scroll down. I just want to say something here. Let's have a look at, I just want to start. It says, notwithstanding the fact that there is no legal prohibition preventing Muslims from entering civil marriage in terms of the Marriage Act, thereby allowing to access to and protection of the legal consequences that flow from civil marriage, very few Muslims exercise this opinion. It is admitted that the following are reasons for Muslims not exercising the option of entering into civil marriage within the statutory legislation of South Africa beyond the Islamic rights. The ulama actively discourage Muslims from entering into civil marriages as they advocate the view that civil marriages are un-Islamic. The ulama regards civil marriages as un-Islamic because it precludes the parties from entering into polygamous marriages, and the default matrimonial property system is that of in-community property, which is contrary to the teaching and principles of Islam. That's the one reason. The other one is it's not part of the culture of Muslims in South Africa to conclude a civil marriage in addition to a marriage concluded in terms of the Muslim rights. There you have it. Very, very difficult. So yes, here I look at statutory recognition of Islamic law. Let's have a look at it. Limited legal recognition has been granted to religious marriages by means of various pieces of legislation. The legislature has in certain statutes explicitly include spouses who are married in terms of religious law. These statutes do this by defining the term marriage to include a religious marriage, or by defining the term spouse to include a partner married by religious law. So that's how they include it. For the purpose of Birth and Death Registration Act, the Children's Act, the Domestic Violence Act, the Insolvency Act, and the Criminal Procedure Act, the term marriage includes a customary unit concluded according to indigenous law or custom, and a marriage solemnized and concluded according to the tenets of any religion. The pressure is on. Whether our religious faith basis is like it or not, promulgates legislation consistent with the Constitution is pulling the religious people by definition into the Act, and if you violate it, look at that, Criminal Procedure Act, you can be in serious trouble. They also talk about income tax, transfer duty, estate duty, pension, civil proceeding, evidence, succession, spites, define the term spouse to include a partner in union recognized as a marriage in accordance with the tenets of any religion. Now those are big acts we are mentioning there, and they all undermine the right, the Islamic right, and the Islamic and other religious rights on their faith convictions. So yes, you can imagine that this is very difficult. Okay, great. We've got a 2018 case. The recent decision of the Women's Legal Trust versus President of the Republic, Farah versus Bingham and Eso versus Eso 2018, held that all the provision of the Divorce Act shall be applicable to marriages concluded in terms of Muslim rights, save that all Muslim marriages shall be treated as if they are out of community and property, except where there are agreements to the contrary. Furthermore, the court held that the provision of Section 7.3 of the Divorce Act, redistributor orders for the transfer of assets, shall apply to Muslim marriages regardless of when it was concluded. Now, ladies and gentlemen, there you can see it. And you can see why the imams and all the religious leaders in all faith bases, because remember, this might be an Islamic case, but it's applied to all the faith religious foundations out there. So at the end of the day, this is lawmaking, and you can see why there is extremely unhappiness, and why you have to advise your clients in the right manner. How is this going to turn out, etc., etc. Alright, so that is rough stuff, that is rough stuff, but it's the way it is, and it is consistent with the Constitution, because if you look at it, it protects especially women in terms of a lot of things, maintenance for the children, for themselves, assets, etc., etc. So yeah, it's difficult, it's very difficult. Now, what about our constitutional institution of Islamic law? You will remember I said that it must be consistent. If it's not consistent, it will be declared invalid. Then I talk about it. I want to read this specific one here. Section 15.3 provides as follows. This section does not prevent legislation recognizing marriages concluded under any tradition or a system of religious personal family law. So everybody is happy, right? Systems of personal and family law under any tradition or adhered to by persons professing a particular religion, and everybody is happy. And then suddenly, the but. Here comes the but. Recognition in terms of the aforementioned must be consistent with this section and the other provision of the Constitution. So there you have it. That is what is problematic. Section 51 appears to grant those who wish to be married in terms of religion the freedom to do so because it involves a decision based on conscience through belief, opinion, and religion. But in terms of Section 15.3a, they say it must be consistent. End of the story. The Constitution does not allow the explicit endorsement of one religion over others. That's very important in this guide too. And this would amount to threat to the free exercise of religion. When governmental prestige, power and financial support are placed behind a particular religious system, the result is that the religious minorities are indirectly forced to conform to the religion officially approved by the government, which in apartheid years was Christianity. The Constitution requires the legislature to refrain from favoring one religion over others. Fairness and even-handedness in relation to diverse religions is a necessary component of the right to freedom of religion. In this respect, in the case of Lawrence Negal as well as Solberg, Judge Sachs commented as follows. The Constitution then is very much about the acknowledgement by the state of different belief systems and their accommodation within a non-hierarchical framework of equality and non-discrimination. It's all about not non-discrimination. It's all about unfair discrimination actually, but we'll accept what he said. In any event, that is a very big judge. I've got a lot of respect for him. It follows that a state does not side on questions of religion. It does not impose beliefs, grant privilege to impose advantages on adherents of any particular beliefs, required conformity, and matters simply of belief involve itself in purely religious controversies or marginalize people who have different beliefs. And we have seen in South Africa in recent years political leaders of certain political parties actually attacking certain faith foundations. And so if they become the president of the country, one would wonder how they're going to impact on amendment within the Constitution in terms of religious freedom. So these things are very important. Alright guys, then you have to go through that, read through that in your own time then. They talk there about Section 9, also equality. Furthermore, Section 30 of the Constitution affords everyone the right to participate in a cultural life of his or her choice. And Section 31 furthermore provides that person belonging to a cultural community may not be denied the right to enjoy their culture. Interesting enough is a lot of the very old religious foundations has created cultures. Muslims has got their cultures, Jews has got their cultures. Christians as their cultures. I think Christian is the most diverse in terms of cultures because Christian Faith Foundation is diversified. Under the Christian Faith Foundation you get hundreds of sub-Christian divisions and ideologies, etc., all with their own faith orientation. For example, the Mormons, Jehovah's Witnesses, the Protestants, the Catholics. So you have a whole different division there. But out of those religious views, very old, comes cultures, and that is also protected. By protecting that also, you are protecting certain religious views, but again, even the cultures subject to being consistent to the Constitution, and that's the way it's done. Alright guys, although customaries are based on custom, and in addition there are customary marriage, then Muslim marriages granting recognition of customary marriage and not the Muslim marriage is tantamount to discrimination. There is no reason for accepting the arguments for customary marriage but not Islamic marriages. Religious-based marriages giving effect to personal and family law often regarded as discriminating against women. For example, polygamy is seen as discriminating against women. In Jewish and Muslim law, it's easier for men to divorce their wives than women to divorce their husbands. On the grounds of gender and sexual orientation, it is submitted that this discrimination should be permissible insofar as is required to bear the tenets of the religion. I can tell you that's never going to happen. They're talking about the Jews and Muslims there. Let me throw something in there. In Christianity years ago in South Africa, the same for women, very difficult. You can just the same, precisely the same Jews, Muslim, but in recent days, due to the change of the calculus, that has changed. So these things are interesting. Very interesting subject this. The right to culture, we just spoke about it. Court cases, I have to stand still at. Let's have Section 30 in terms of a court case. We are in 1999, so it's post 1996. Christian Education South Africa Minister of Education illustrated this principle. In this case, the applicant association representing 196 independent Christian schools challenged the constitutionality of Section 10 of the South African Schools Act, which is 84 of 1996, that prohibited the administration of corporal punishment. Do you remember that one? That was a big one. And what happened there? The applicant contended that it constituted a violation of religious and cultural freedom, since corporal punishment of children was a vital part of the Christian religion. It's not only part of the Christian religion, it comes out of the Talmud, it comes out of the Protestant and Catholic Bible, and it says that corporal punishment is essential. Children must be punished in this way. The High Court held that the applicant had not shown that the belief in corporal punishment was sincerely held religious belief, nor that the prohibition constituted a substantial burden on the freedom of religion of the association members, since other forms of punishment and correction of children that were acceptable to the members of the association were not prohibited by the South African Schools Act. With regard to the argument that a prohibition was a violation of the right to practice a religion in community with others in terms of that section, in court held that because corporal punishment was an infringement of the right to dignity and freedom from degrading punishment contained in the Bill of Rights, and to allow corporal punishment to be administered in the applicant school, even if it's done in the exercise of religious beliefs or culture of those involved, would be to allow the applicant's members to practice their religion or culture in a manner inconsistent with the Bill of Rights and a contravention of section so of the Constitution. Then they took it on appeal. However, the court remarked that section 312 ensures that members of communities cannot use their right to culture and religions to shield practices which offend the Bill of Rights, and that's what I did there, and corporal punishment was out of schools. So yeah, you can imagine that a lot of people, especially the Christian faith-based faiths, were very upset about this. They wanted their children to be disciplined at school, but you know what, I understand where the Constitutional Court came from in this sense, in terms of unfair discrimination. You never know, a certain religious group can target the other religious group and really beat those kids up very badly. So I understand that for equality in a rainbow nation where we have different fair foundations, that actually to a certain extent the ruling here protects our children in schools from religious fanatics, where they would say, well, you know, I'm from this faith, you're from that faith, I'm going to look for a reason to just give you corporal punishment. So at the end of the day, if you really think about it, although the religious-based foundations, I totally understand. Doesn't matter from what religion you come, I totally understand it. When I've read this quote many times, and I think this actually protected our children from fanatics, and you know, you always find out later who a fanatic is, not beforehand, and then of course the school can deal with fanatics and change them out, because nobody wants for religious fanatics in control, because you know what happens then. So this is very interesting, but yeah, that's interesting. I actually agree totally with that court case that they made there, and I understand why they made it. I myself might not even agree with it, but I totally understand where they are coming from. So you can read up in that. You have to have the right to dignity. Now, interesting, and this is a good one. You all would remember this one. Hess versus Makwanyane in 1995, waived the death sentence, and they also told her which fundamental rights were the most important rights in your country, the right to life, and all of those things. So that is a very, very good case to go and read. Let's have a look at it. And of course, Hess versus Makwanyane is important. Why? Because he told us totally how to apply the general limitation clause in the Bill of Rights in the Constitution, Chapter 2, in terms of how those 5 questions should be answered, etc., etc. Now, they, in this specific case, what did they say there? Recognize a right to dignity and acknowledgement of the intrinsic worth of human beings. Human beings are entitled to be treated as worthy of respect and concern. This right, therefore, is the foundation of many of the other rights that are specifically entrenched in the Bill of Rights. Now, what they are saying here is men and women are equal and they should be treated equal. And this is where all religious foundations, it doesn't matter which one, they sometimes come out in terms of the man being more powerful, entitled to more than a woman, etc., as well as on the other foundations. And this is what he's saying. They say, well, you know what, they're all equal, they should be treated the same, and they should have all the same, and this is important what I'm saying now, remedial recourses under the law if they feel that their rights are being infringed or they're unfairly being discriminated against. Because the one thing that all our faith foundations are saying, they're actually saying what? Yes, we are discriminated against women, but in terms of our rights, R-I-T-S, religious rights, it is fair. Our Constitution says, no, that is unfair, and then of course you're infringing on their rights, and if it's unfair, then you don't allow him constitutionally the same remedial recourses as men are getting, or other associations are getting, or whatever the situation might be. Interesting cases to argue in court. The rights to life and dignity are the most important of all human rights and the source of all personal rights, and the Bill of Rights. By committing ourselves to a society founded on the recognition of human rights, we are required to value these two rights above all others. And they go on to deal with that. So we understand what they're saying. They are actually saying, well, where a religious right takes away equality, especially in terms of remedial recourses, we cannot allow that. We cannot allow individuals, specifically male and female, to have different rights. A little one is more stronger, other one is more lesser. We cannot have it in a community based on a democratic dispensation of equality. I love this stuff. Don't you love it? You guys study this, legal practitioners. This is so interesting. In respect of marriage and family life, Van der Heeren said in 2000, a new case actually, the Dawood case, that a right to dignity must be interpreted to afford legal protection to the institution of marriage life and family life, with this protection extending at the very least to the core elements of these institutions, namely, the right and duty of spouses to live together as spouses in a community of life. The above approach, as expounded by Van Heeren judge, was confirmed by the Constitutional Court by O'Regan, and he held that the Constitutional Court indeed protected the rights of persons to marry freely or to raise a family. In this respect, they said the following: the decision to enter into a marriage relationship and to sustain such a relationship is a matter of defined significance for many, if not most people, and to prohibit the establishment of such a relationship impairs the ability of the individual to achieve personal fulfillment in an aspect of life that is of central significance. In my view, such legislation would clearly constitute an infringement of the right of dignity. It's not only legislation that prohibits the right to form a marriage relationship that will constitute an infringement of the right of dignity, but any legislation that significantly impairs the ability of spouses to honor their obligations to one another would also limit that right. A central aspect of marriage is cohabitation, the right to live together. The legislation that significantly impairs the ability of the spouses to honor that obligation would also constitute a limitation of the right to dignity. So this is the one take on it. This take is, listen, they can marry as they want to. There's no problem with it. And what Van Heeren is saying, what O'Regan is saying, if you really read it, they're not going against inconsistency with the Constitution. They are actually going in terms of balancing the rights correctly. They're not saying it in so many words, but they're saying you cannot discriminate against different religions as they want to marry if they want to marry, but they're also talking about the right of dignity in terms of balancing. And when they talk about living together, etc., you'll see they are not specifically referring to the problems arising later on where a balanced, equal setting of remedial recourses is required to settle disputes. They're talking about living together and all of those things, and I totally agree with that. But we have to deal with what happens with the fairness of equality when divorces and maintenance and all of those things arise. Assets and all of those things. So that's very interesting. Alright, if we go down, they talk a little bit to the right of equality, because that is the whole issue. Equality is the whole issue. Everybody is equal before the law. It doesn't matter from what religion, it doesn't matter where you're coming from, male or female or child. It does not matter. Neutral sexual orientation or specific other sexual orientation, it does not matter. Everybody is equal in front of the law and must be equally treated as such. And there they say in the Ismail versus Ismail case, a very well-known case actually, which came out of 1983, they say there, in so-and-so Muslim marriage were denied recognition on the ground that they violated the principle of equality on two respects. Firstly, the bride is not present at a ceremony, and secondly, it is more difficult for women than to men to obtain a divorce. Kaganas and Mari argued that possibly the equality issue was invoked in Ismail merely to provide a new rationalization for old prejudices, and of course we cannot allow that. We also saw there, you can further go and see what Ruth is arguing. The husband determines the composition of the family alone. Women bear responsibility for the children, yet have no rights over them. Husbands are often unable to give sufficient money and attention to all their wives. Women are allowed to be dominated, sexually stereotyped, and treated as property. And obviously, all of you looking at this, surely all of you looking at this would say to me, but those times are over. Those times are over when this kind of traumatic emotional bullying and manipulation can be allowed in a democratic dispensation. And we all understand it, because we understand that when you treat other people as property, then you assault them. Also sometimes you rape them, you hurt them, you emotionally abuse them. So it stems from that kind of behavior. And then, of course, that's not to say, don't get me wrong, there is religious-based husbands that from the beginning of old times respect their wives, looks very well after them. But we cannot allow things like this anymore. So we have to be in line with the Constitution, not inconsistent with things. And then we are out of all of this. What are we talking about? First of all, the right to dignity. We cannot treat other people like that, because remember, when we talk about marriage, we're not talking about women alone. Women are married. Men are married. And whoever takes the inferior role can be classified under this, etc., etc. So these are the things that are concerning, and you have to have an open mind if you're going to take instructions like this. Alright, we've got about 24 minutes left in this one. Let's scroll down, see what we have here. You're going to go and read through all that. I'm looking for something that is important for me to discuss with you. I'm looking for court cases. There they talk about Ishmael versus Ishmael again. Let's just see here. They're talking now about the judicial recognition of Islamic law. So before the enactment of the Constitution, there in 1907, the Sidat's case, they afforded no legitimacy to marriage concluded under Islamic rights. You can go and read that. That was in 1917. Nothing. They don't recognize it. And you can read through it because it's excellent. Now we know what happened in Ishmael. And then the summary there I want to bring to you. The decision Sidat and Ishmael once again confirmed support for the non-recognition of polygamous and unions. The courts took the view that the status of sole marriage would be undermined if polygamous unions were recognized. In both these cases, it was irrelevant to the judiciary whether or not Muslim marriages are actually monogamous during the lifetime of the spouses, or that a marriage had been concluded in a country that regarded as legal valid. I told you that in their countries this is valid. They don't have separation of acts. The Islamic law is the religion and it's the law. And in countries like us that's going to democratic dispensation, then that changes. The mere fact that Muslim marriages were regarded as being potentially polygamous precluded any legal recognition. Now, after the enactment of our Constitution, we go to Carlo and another, 1994, the Matters and others. Remember, you would say 1994, I would say don't worry about it. We had the interim process there. One of the first cases to be decided in terms of the interim constitution, there you have it. This case involved freedom of religion and in particular the validity of marriages conducted according to the Islamic rights. In this case concerning a will executed in 1977, the deceased, who had married his wife by Islamic rights in India in 1948, bequeathed 20,000 rand to her and a further 20,000 rand to the local mosque. The wife challenged this in court and claimed apportionment of the deceased estate on the ground that she's been married in community of property, and further that the universal part existed between her and her husband. Very clever argument in those days. Excellent argument. Do you see that? It is interesting to know that a marriage has been recognized by the Department of Home Affairs, a record and population register. That was interesting in those days. The Kala case raised the question whether Section 41, which entrenches the freedom of conscience, religion, thought, belief and opinion, opened the door to the recognition of hitherto invalid polygamous unions concluded under systems of religious laws. The court disposed of the wife's contentions with the argument that Section 2418 of the interim constitution precludes the retroactive operation of Section 40. Can you believe that? That is such a weak argument. As the events material to the case occurred before the commencement of the Constitution, the decision of the master's recognition the marriage as valid marriages were thereby set aside. Can you believe that? What an atrocity. Let's go to 1997 and look what they did in Ryland versus Edros. That makes me so mad, so mad, because I have been a legal practitioner. I'm a senior advocate. I'm not a senior counsel. I've never applied for it. I'm not interested, but I've been an advocate for years. and I can see the scapegoat approach there. Such as they could have created law there. Makes me so mad. Alright, let's go on before I get more upset about that court case. Really, they under the Indian Constitution, they already had a right to make new law, and they didn't do it. Bad on them. Ryland versus Eerdros, 1997. The decision that finally broke the long-established pattern of non-recognition of potentially polygamous marriages that are de facto monogamous was the Ryland case. The importance of this case lies in the fact that it redefines the meaning that has been attributed to the term public policy as it was understood in our legal system before 1994. The case also showed that certain consequences of marriage relations had not been granted legal recognition because of the potential polygamous nature could be enforced. In this case, the parties entered into monogamous marriage according to the Muslim rights in 1976. The husband divorced the wife in 1992 by suing her with a talaq. The plaintiff instituted an action to have the defendant evicted from the matrimonial home. You see where it's going. And the defendant in the return claimed for rear maintenance. A consolatory gift as the defendant wife alleged the divorce without just cause, and an equitable share on the growth of her husband's estate, as the defendant alleged that she had contributed labour, effort and money to the husband's estate. So that's a very well-known argument in all the court cases, and Christian court cases also, very well-known argument. The court was not compelled to demand the validity of the marriage or grant recognition to the marriage, but was required to decide whether the decision in the Ishmael case prevented the parties from relying on a marriage contract that formed the basis of the Muslim marriage. To reach a decision concerning the Farlam judge had a lot to say there. Farlam had to determine whether or not public policy that previously dictated non-enforcement. They had to look at that. The court held that the Rachel and Ismail case was in conflict. There you go. And the conflict with what? Ubuntu. The conflict with the spirit, purport and objects, Ubuntu, of the Constitution. Therefore, the values underlying that of the Constitution must prevail. The learned judge further asserted that the values of equality and tolerance of diversity and the recognition of the plural nature of our society among the values to underlying Constitution, consequently held that the Ismail decision no longer operated to preclude the court from enforcing such rights. That's why they called him the Linde judge. I agree with that. The essence of the judgment was the contractual agreements flowing from the marriage, that its potential polygamous nature would not be rendered unenforceable, provided that the terms of obligation emanating from such courts are not contrary to public policy. Public policy is so important in terms of our democratic constitution. I'm writing the book now on contracts, and if you look at Beadika, Botha, and those court cases, you'll see a contractual clause must not be against public policy. It was also held that public policy is essential a question of fact. Furthermore, public opinion can alter from time to time. That's the calculus. This case opens the door for revolving. The then Cape Supreme Court gave limited recognition to marriage provided that was monogamous unit. It held in effect that the spouse are bound as against each other by the contractual undertakings on Islamic law. Despite a progressive decision taking in the Ryland case, the following comments can be made. Firstly, extensive investigation of polygamy was not concluded. Second, the decision is only applicable to unions that are de facto monogamous. So, he was a learned judge. I liked what he did. He started the road on a better foundation. Alright guys, so go through those court cases there. You'll see there's the Almond court case. The applicant contended there that the deceased husband had a contractual duty to support the Tanzania law. They didn't do that. The court held that due to the decision of Ishmael case was held Muslim rights are contrary to public policy. He went there with regard to the second Army Court held that there was no provision in the Constitution that indicated was to have legislative powers. The court further held that intention behind so and so. The matter was taken on appeal, was made to the Supreme Court of Appeal, found that, let's see what they did. The test is down in sometime. I just want to see what they find. The court found that Mrs. Ahmad was owed a legal duty of support arising from a marriage. Accordingly, the MNFA was held that to be legally liable to compensate a widow for loss of support of a deceased husband. For the first time in South Africa, a court was prepared to recognize an action for loss of support by surviving Muslim spouse married in terms of Islamic law. Thank you very much for the Ahmad case there. Alright guys, you can take it further. Read further. There we can see that as we are progressing into the future, things are starting to get better. I just need to have to now start going through this. You've got to read all of it. I now start and get going to the end of it to show you the demographics, to show you the demographics. You're going to go through all of this, but you have picked up the trend. I think we have laid down for the foundation for the manner in which you must think. Here we have something I need to quickly discuss with you. It's Supreme Court of Appeal 2020 Women's Legal Center court case. The decision of this case, discussed under 6.6.2 above, went on appeal. And the order was made the following: the Marriage Act, so Divorce Act, are declared to be inconsistent with the Constitution, and in that they failed to recognize marriage solemn in accordance with the Muslim marriages. They say the Divorce Act is inconsistent again, Muslim marriages. It declared Section 9 was inconsistent. The declaration of validity are referred to Constitutional Court for confirmation. The common law definition of marriage is declared to be inconsistent. And that is how our law came to act, our Marriage Acts, our Union Acts, that is as for. And they say also Divorce Acts as follows: all the divorce shall be applicable, save the Muslim marriage shall be treated as if they are out of community of property. The Divorce Act shall apply, they go on there, and that is a very good court case. You have to go through it, where they totally changed our legislation, and all the promulgated legislation that were inconsistent with, in terms of the Constitution pertaining to this, was declared inconsistent. And that's the adjustment in effect means that the Divorce Act used in civil matters is being ordered as an interim relief for women married under Muslim rights until legislation act to protect them. So they had to fix the legislation in cases where the husband had no more than one spouse. The court ordered that the court shall take into consideration all relevant factors, including contracts agreements. It must be made equal with others. So there you have it. That's what that was all about. Let's just quickly see what we did here. I just want to see here. Muslim personal law, you can go through this. This is the vision, the betrothal of engagement introduction. You go deep into the Muslim law here. We only have 13 minutes before we have to move on to decision in the indigenous law, on the customary laws. You've got to look at that. Definition of a marriage. According to Siddiqui, marriage is defined as a relation between a man and a woman which is recognized by custom or law and involves certain rights and obligations, both in the case of the parties entering into union and in the case of the children born of it. And they also give you there another way in which they define it. Please have a look at that. Comparison between Islamic law and South African law. Definition of a marriage. Obviously there is still things that is a problem, but I say the legal requirements for a valid marriage, the sexual considered legal requirements, going to go through that. Legal capacity, age. These ages in the religious faith foundations, they differ a lot. Mental capacity you have to look at. Consent. In certain instances people can literally be minors, and if consent is given by the guardians, they can marry. Those things we can allow any more lawfulness. They talk about the permanent impediments there. You have to go through that. Temporary impediments. I'm going through this very quickly, guys. I'm just supposed to talk on it for an hour and a half. Your witnessing to marriage is important. I want to get to the end now where I can show you the demographics. That is important. You've got to move through all of this, but we've laid a foundation. We've laid a foundation. The understanding you need to understand what you should do when you deal with these things are very important. And you've got to look at maintenance, the nafaqah, all of those things under the Muslim law, residence, treatment of wives, equality between wives, the duties of wives, guarding the husband's rights, managing of household affairs, headship of the family, all of those things, family name, comparison between Islamic law and South African law, personal consequence of marriage. These things are so important. The property rights, there's the access. This is one of the things that we can get a lot of unfair discrimination. The marriage contract also, what is in there, what are they doing with that? Comparison between Islamic law and South African law, property rights of the marriage. Then we talk about divorces, the dissolution, and then in terms of, and also dissolution by death. The law of inheritance, we saw a court case, we just discussed that court case up there. Comparison between Islamic law and South African law, dissolution of marriage by death, go through that. Then I talk about dissolution of a marriage by divorce, introduction. That is where the biggest fights come in. If you measure against secular laws and the faith-based religious laws, pre-divorce procedure, this is actually very interesting. I've seen with the Muslims actually that I find that the way they do divorces, other than other religions I've read on, that they make certain that there's no animosity. It goes through a process. I really liked reading that. That was very interesting for me, because people usually hate each other after divorces, and to a certain degree they don't allow the divorce to be finalized until those two people have peace. I was so impressed with that. So there's a lot of things you can look at. You can read through all of this. I just want to get to the demographics now, because that's important. There's a lot of things you have to go through. The Ida, they talk about different kinds of Ida. The Ida of women who menstruate, the Ida of Mustahada, the Ida of women who have passed the age of menstruation, the Ida of a widow, they talk about that, the Ida of a pregnant woman, the rights of the woman in Ida, compensation between Islamic law and South African law, dissolution of marriage by divorce. We've put up 3 multi-choices. You'll do 2 of those 3 multi-choices to take you through this guide, because I'm going through it very fast, but don't worry about that. We have drafted 200 multi-choice questions for you. You're going to do 100, but if you fail that, you get an opportunity to do the supplementary, and it takes you through the whole guide, so you don't have to worry about me going too fast through it. There's economic consequence of a divorce, introduction, division of the marital maintenance, nafaqah, after dissolution of the marriage. Like I say, I'm struggling with the pronunciation here, please excuse me. Position of the dowry on divorce, have a look at that. Inheritances, pension sharing, important one in our divorces. Comparisons between Islamic and South African economic consequence of divorce, yet again. Conclusion, and when they go to the conclusion, hopefully we're going to get where we want to get now. This is again Muslim personal law in South Africa, the introduction, historical background. It's not where I want to be yet. I'm getting there, slowly but surely. The draft Muslim marriages bill, that's what I was talking about. They are struggling. They are struggling to get this through. You got to understand, we cannot enact anything through Parliament if it's inconsistent with the recognition of the Constitution, and that's the big problem. And if you're coming from a pure faith-based religion, it's never going to be possible. There's only one way this can be done. It's going to have to be consistent with the Constitution. And let's not kid each other. That's totally opposite of the religious rights in most of these religions. Concerns and criticism. There's a lot of criticism on the bill. At least they started drafting something. It almost went through, and then there was an explosion. Here we have to look at this. The release of the draft bill had left largely unattended since it was drafted. As a result of the failure to table the draft bill after its release in 2003, the Women's League Centre brought an application for direct access to Constitutional Court seeking an order to force the President and Parliament to enact a law recognizing Muslim marriages. They did that. They brought it. The court, in dealing with this issue, narrowed its arguments to that of jurisdiction. The court further held that the power to grant litigants direct outside the court's exclusive competence is one that is rarely exercised by the court, and with good reason. Despite dismissing the application for direct access, the court emphasized that the outcome of the present application does not reflect on the substance of the claim that the President of Parliament are under a duty to enact legislation recognizing Muslim marriage. That says it. That says that they will not act counter the Constitution, but direct access is Rule 18. They brought it and the court says they will not allow direct access. That's what I did there. So they passed it back to the court, Aquawa. That's what I did there. Difference between the 2000 and the TINA Act there. So they tried again. They went back and they redrafted. Appointment of Muslim judges. Islamic prescribes that a judge be appointed on the basis of Islamic knowledge in his areas. That is very dangerous. Do things like that. All the religions are going to ask for that. Appointment of assessors, concerns and criticisms. Again, you can go through that. We do take you through all of it, and so on. And there you have a case there, the Daniel Wilson Campbell. These cases we have gone, you have written up before in this guide. You can go and look at that. I want to get to the demographics because you need to know that. Then we talk about a Muslim Marriage Act, the recommendations there, you can go through that. A lot of things in here. General legislation, please read through that. Single marriage statutes, name of the statute, recognition, the partnership bill, minimum age requirements, consents, and the conclusion there. Hopefully we should. Alright, here we are. Here's the demographics. Let's quickly have a look at it. We've got about 6 minutes to do that. Other religions around South Africa. What's happening in South Africa? And that is your learning outcomes. Here we say the demographics of other religions in South Africa. Although a major part of this guide has been in relation to the concept of Islam and Muslim, it must not be construed as creating the impression that other religions by any means inferior. It is a question of demographics on the foundation of constitutional development, and the most active arguments and debates in lawmaking in terms of exposure throughout South Africa, and one just needs to observe case precedent amongst others to detect the location for the most active legislative developments. Let's attend to the religious demographic at the hand of a reputable institution. So what are they saying to us there? Percentage distribution of religion observed by religious affiliation 2018 in South Africa. I give you the percentage now. So if you look at the percentages there, you'll see that they set it out there, and if we go down here, you'll see that they give it you in the 9 provinces and in totality. Percentage distribution of religious affiliation by province, you see 86%. I give you the provinces, but 86% of South Africa, according to the 2050. We're in 2021 now. So they say there was at that stage 86%. Muslims 1.9. The ancestral and indigenous law, which we're doing in part 2 of this guide, is 5.4. That is the second biggest. Hindus is 0.9, Jews 0.2, other religions 0.4, nothing in particular 5.2, and do not know 0.0. There was a one in the Western Cape, and one there in the Gauteng province. I don't know where I resolved. So that's the demographics. And if you take the Muslim and Islam, that Muslims come from Islam, that's 1.9 against the others. That's why we are having more of those court cases in your country. And of course we have our own gate for ancestral, tribal, and most other traditional African religions. That is 5.4. We call that indigenous law. And then they explain that further there. They say that these courts, the 7 divisions that follow the Muslim faith, attend the religious services ceremonies. Interesting enough is that although Christianity is the biggest, their attendance percentage-wise to physical gatherings is lower than the Muslims. The Muslims are very disciplined and they attend their gatherings. We are 50 point, the Christians are 50.5, and there we have the Hindus at 36.6. And you can see how far down is 50, far down from the Muslims, that you got to take your hat off to them in terms of the attendance of the sermons and the gatherings. Is very good. Individuals affiliated to this religion is 6.7. We're most likely to never attended this service by Muslims, 8.4, and Hindus 6.6 there. So they talk about global religion. According to a study by Pew Research, says Islam is growing faster than any other religion. Most of the world's major religions are expected to rise in absolute numbers by 2050. The research finds with Islam set to overtake Christianity and become the world's dominant religion by 2070. So there you can have a look at it. Now this is international statistic, not South African statistic. 31, 29, you can see there. And unaffiliated 13, Hindus 14, Buddhists 5.2, folk religion, other religions, and Jewish people is 0.2. And they say actually there, I just came down too fast now. In 2050, they say that, yeah, we can go down. All right. So there you have that. Now let's quickly look at some of the divisions. Definitions and concept of various religions. Now, like I said, these guides are still being drafted, so don't worry about how it looks. Your guides are going to be 100% correct. This was just built in, so it still has to go through the formatic situation. We can quickly look there at this mouse of mine. Christianity. Christianity is the most widely practiced religion in the world. So we give you a background. We give you some of the beliefs. We give you Hinduism's background. The basic concept of Hinduism is diverse. No single doctrine or set of beliefs can represent its numerous traditions. And we give you there a little bit of that. And the two main schools of Vedanta, which is Advaita and Vaita monistic. So there we talk about that and the overview of the Hindu theology. So what we are doing here to understand legislation better that you're dealing with as a legal practitioner, we got to teach you what these different religions are. The most common ones in South Africa, and we selected it at a hand of 4. Then we talk at Buddhism and the basic teaching of Buddha. Then we talk about Judaism and the basic meanings. Judaism means living the faith, and we talk about all of that. Then we show you. This is what we are showing you. Like I said, we're still finalizing this guide, but we need to get these recordings out so that you have it. There might even be more recordings later on. I'm going to try and push for you guys on that. There we have the case of 2000. It's an important case in South African law. There's the facts. We're going to clean this up for you when you get your guide. And having been on sectional court at Kwao, the appellant was granted leave to appeal to the Constitutional Court on the grounds that the blanket prohibition contains Section 10 of the Act infringes the provisions in the Constitutional Privacy freedom of religion, there you have it, belief and opinion, and the education, it goes on there. So these were the important things that you have to look at. And it had to do with corporal punishment. We already discussed it. We are using this to show you that from the Christianity phase both, we also have purely Christianity based court cases. The same with Hinduism, there we take that as number 2. In the case of Singh versus Ramparshat, stemming from the Hindu religion, the following transpired. Himla who launched a constitutional aim at getting an unregistered Hindu marriage recognized in law so that she could get divorced, has failed in her attempt. So we had a court case there. So you cannot take in South Africa, due to our constitution, religious issues out of our law, because when people are unhappy, they're going to approach the court. We just wanted to show you that all the religions, all the common religions are represented. This is what we're trying to do to you, so that you don't think in part 1 when you look at Islam law and Muslims that, hey, where is the Hindus, where's the Christians, where's the other religions? They are here. They are here, and we just wanted to show you that no religion is we deem more important than another one. And our time is up, but I'm going to finish up. I'm not going to worry about that. That was in India. We have a court case there. Then we went to Buddhism. There we have the Lawrence case. Now actually we spoke to you about the Lawrence case up in the guide. Lawrence, Nigal and Sassel, they were charged in massive courts, convicted intervention of the Liquor Act. That was an interesting case. You can read up on them. You can go through here, and just to show you guys that it doesn't matter what religion you are, that when people are unhappy, they're going to go to our courts. And then we go to Judaism. And in Judaism, we cannot say the court case name because we've got minors there, and there's a maintenance court case going on there, and there's also a court case that went on. But if you research it on the internet, you will find it there. And ladies and gentlemen, I apologize for the hasty way we did it, but unfortunately we only had an hour and a half. We'll see if we can get something out more to you. And of course, don't worry about a guide. The guide's going to look totally different when it reached you. And alright, that's it for me. For now, I think I'm out of here. And I'll prepare for part 2 in indigenous law, traditionally in South Africa, and we'll take it from there. So yeah, that was fun. That was fun. It's very interesting. It's very nice to spend time with you, even though it's limited time. But we enjoy doing that. And the one thing I can say about this specific subject is that if you're going to practice law in this direction, or you are a religious legal practitioner that's going to practice law for your religion, then make certain that you totally know what's going on and you totally understand the Constitution and you see where we came from. We came from cases in the past, 1983, where people were trying to do the right thing, but they were afraid. Then we had cases just after 1995 where people did the right thing, but they limited, they didn't really need to go. Where we are sitting now, we see that a court is literally declaring pieces of legislation unconstitutional, where it unfairly impacts negatively on your right to freedom of religion. But bearing in mind, being consistent with the Constitution, not inconsistent. That's your argument. 2-3 sentences. That is your argument. Advocate James Clark from the High Supreme Court. Nice spending time from you, and I'll talk to you in part 2. You'll find that a little bit later. Be safe, and guys, always be honest, have passion for your job, and grow into a very strong, profitable and ethical legal practitioner.